Welcome, everybody. And it is so fantastic that you've been able to join us here today. As you can see, we've just been having a little bit of catch-up chat before we start this seminar today. For everyone who hasn't attended our events before, my name is Norni Lijon, and I'm Director of the Information Law and Policy Centre, one of the academic centres based at the University of London's Institute of Advanced Legal Studies. Thanks so much for taking the time to be with us for our first seminar, launching the Centre's new series on AI and the humanities, transforming society. So this series will explore the societal impacts of AI-based technologies and systems and the role of the humanities and social sciences in providing key insights and expert analysis, enabling an open dialogue on these important and complex issues with the public. So it is my very great pleasure to chair and to introduce our distinguished panel today for a very timely and important discussion on the regulation of high-risk AI systems. There'll be a particular focus on the EU's proposed AI regulation, which is otherwise known as the AI Act. It forms part of a wider set of proposed laws intended to enable the trustworthy and secure development of artificial intelligence in Europe. So our lead speaker today is Professor Lillian Edwards. Professor Edwards was appointed Chair in Law, Innovation and Society at Newcastle University in 2018 and is expert legal advisor to the Ada Lovelace Institute. She is a leading academic in the field of internet law and has taught information technology law, e-commerce law, and privacy law since 1996, and she's been involved with law and AI since 1985. Her research involves a broad consideration of the regulation of new technologies, especially the internet and the Internet of Things. She specializes in privacy and data protection, especially as applied to AI and algorithms, algorithmic transparency and justice, and the regulation of digital platforms. Her work also covers COVID-19 data-driven technologies, sponsored by the Arts and Humanities Research Council, and Leverhulme Trust-funded work on digital assets and post-mortem privacy. Previously, she worked at the University of Edinburgh's Faculty of Law, where she created one of the EU's first programs in internet law. She was also co-founder of the Scripps Centre for Research into Intellectual Property and Technology Law, and she has subsequently held chairs of internet law at the Universities of Southampton, Sheffield, and Strathclyde. Professor Edwards continues to head up digital law work at Newcastle University and leads on regulation of data for the Data NU Core. She is a fellow of the Alan Turing Institute, the UK's National Institute for Data Science and AI, and a partner of the Horizon Digital Hub at Nottingham University. So following Lillian's main presentation, an intervention will then be provided by our discussant, Dr. Petra Molnar. Petra is a lawyer and anthropologist and the Associate Director of the Refugee Law Lab at York University in Canada. Her current work focuses on the impacts of surveillance technologies on people crossing borders, and she splits her time in work between Canada and Greece. She is currently working on her first book, Artificial Borders, AI Surveillance and Border Tech Experiments. So Lillian and Petra, you're very welcome, and we're thrilled that you've been able to join us today. In terms of the format for today's seminar, once the panel has presented, we'll open up the discussion to the digital floor. So please include any questions or comments you have for the panel in the chat box below, and we'll do our best to answer as many questions as possible in the remaining time. So now I would like to thank our speakers, share some apologies for our slightly late start again, thanking all the participants for joining us. And I'll now invite Professor Edwards to begin today's seminar with a presentation on a recent report she's published on the proposed EU AI Act in her role as legal expert advisor to the Ada Lovelace Institute. So Lillian, whenever you're ready.
Thanks, Nora. That was a very comprehensive introduction. It's lovely. It's not the usual one on my website. It's just what people use. I am just looking for my presentation. Okay, right. So sorry for the delay. Yes, as Nora very kindly said, I have been spending this year half-time working on secondment for the Ada Lovelace Institute, who work broadly in data and society. And we've been very interested at looking at the shape of the AI Act, the new proposal that came out first of all, in April last year, critiquing that model, which various people have done. And I think, we have some particular interests, such as the interests of users, of you and me in the process. But also, I think might be relevant to some of the people on this call. We are interested in moving beyond just the EU model, because there are obviously very large amounts of the world, including the UK, where I am now, that are not in the EU. The tendency, of course, will be for this to be seen as a global model, a global gold standard, if you like. It's explicitly being positioned in that way, following in the footsteps of the General Data Protection Regulation, the GDPR, which has been exported to, I think, over 100 countries or regions now in some shape or form. And I think one of the questions we need to be asking ourselves, for the long term or the medium term, is what is the global model we want for governance of AI, right? Are we going to slavishly follow the EU model? Has it got it right? What could be fixed? How is it stuck to some extent, in the guide rails of existing European law, internal market law, and European institutions? And these constraints will not be echoed elsewhere in the world. And therefore, perhaps we can make a better model that isn't so constrained. So these are the kind of issues that I'm thinking about ongoing. And there will be a big report on all of that, hopefully coming out probably in the autumn, with any luck. Okay, I'm hoping to hand it in by the end of August. So that's why it's called Getting a Global Model for Regulating AI Right. Okay, and I actually haven't got the link there, but you're very welcome to go to the Ada Lovelace site and look at the expert opinion report, and also a short explainer, which is more or less probably what I'm going to go through on the Act, and people have said they find these useful. So very briefly, I'm going to absolutely skim through stuff so that you can hear Petra drilling down much more on this really crucial issue of migration, about which I know nothing, so I'm very keen to hear about it. The aim and material scope of the AI Act proposal. Now, there's a fundamental tension, you might say, you might push back, but that's how it's always framed, between the protection of fundamental rights, which is clearly, at the heartland to some extent of the EU project, of the European Convention on Human Rights, of the EU Charter of Rights, and the idea that AI is going to produce prosperity for all, for society, AI for good. It's going to make money. It's going to promote innovation. Now, again, you might push back on quite a few elements of that. But right now, in terms of legislation, that's where it's at, is trying to balance these two concepts, okay? Now, that's mum and apple pie. What I think is perhaps slightly less well appreciated about the AI Act is that we already have numerous laws, notably the GDPR, but also laws relating to tort, to product liability, to contract, to criminal law in various ways that deal with aspects of AI systems. But what is, I think, outstanding about the AI Act proposal is it's aiming for an ex-ante solution, a solution beforehand, to build. So some of us are familiar with the idea of privacy by design that has been around for quite a while now, which is the idea that when you're building online or data-driven systems, you should try to get them right to start with, so that they have privacy protection baked in, as it were. So things like enabling anonymization or not collecting more data than the system needs, right? These should be baked in from the start. And the AI Act is kind of the first comprehensive attempt to build that ab initio, ex ante, sorry about all the Latin, idea into a legal framework. So let's get it right to start with, as opposed to picking up the pieces afterwards. And that part of the AI Act, I myself, perhaps naively, find very positive, right? So we're talking about more than just privacy by design. We're talking about fairness by design. We're talking about equality by design. We might even be talking about transparency by design. Now, the model is based on, to a very large extent, on a model that's been around for a really long time in European law, relating to tangible products, things like toys and fridges and machinery and bridges and lifts, really boring stuff. And it was called the New Legislative Framework. And the idea of this was that laws were passed in the EU from the sort of 70s on, saying, from the 80s on, sorry, saying that if you were producing a product that might have dangers, like a toy, let's say dangerous toys were a really worrying thing, then the manufacturer was in the best position to know how that thing was built, how the toy was made, what components went into it, what chemicals, and to try to get it right from the start so that it was safe, so they could meet a set of technical requirements to make that toy safe, which then resulted on certification in getting something called a CE mark. Confirmation that it met European standards. Once you had the CE mark, which many of you will have seen stamped onto your toy, let's say, then it was allowed to be sold, distributed, imported into the EU, throughout the EU. It was a passport for it to be sold. That model worked quite well for products, right? But does it work for AI? And a lot of the critique that's coming from me, from Ada, from other people, is that this has been a mistransplantation, because AI is not a product, AI is not a dishwasher, and I'll come in a minute to why that is, okay? So I'm not going to go into this, but I just want to say that obviously you need a definition of what the Act refers to, which is AI systems that make decisions effectively. And that scope is very wide. It includes not just machine learning approaches, which I think we're all now used to being called, perhaps wrongly, AI, but it also includes rule-based approaches, logic and knowledge-based approaches. And that's important. I suspect that's very important for migration and border control systems, because many of these may be legacy systems that really are just built using old-fashioned rule-based software. And if we were talking only about machine learning, we'd be excluding that from the remit of the AIA. So I'm pleased that the remit, the scope of the Act is wide, and that so far it has not been cut down. It is important to note, as I will in a minute, that the kind of actual substantial effect of the Act is much narrower, and also that it's not the only game in town. So, you're going to have to consider all these other types of EU legislation, if you're talking about the EU, that are also springing up like mushrooms around the place, right? We're having the absolute bonanza of digital legislation right now. And it's also worth noting, I think, probably in the context of border control, etc., that military AI is currently excluded entirely, right? So to go just very briefly to how the AI Act works, it has this idea that's called a risk-based approach, and that really means it's not one size fits all. It's not one set of rules for all AI systems that fitted into that very wide categorization. So there are these 4 categories of risk. This is a very familiar picture to anyone who's been looking around this field. This triangle that the EU promotes. At the top, unacceptable risk. Here we have high risk in the maroon trapezium. Then we have limited risk, which really doesn't matter very much, and I'm not going to talk about. And then we have minimal risk. Now, my colleague Michael Veal, who also gives a lot of talks on this, says, I think rather correctly, that this really ought to be an upside down table rather than a triangle, because really almost all the AI that people come into contact with in the real world, as it were, most people anyway, consumer type people, so social media, search, ad targeting, all that kind of thing, they're down here in minimal risk. They're not affected by the AI Act. It's actually quite a niche act, right? So what I'm going to concentrate on is the first 2, and primarily high risk, okay? So let me just do the unacceptable risk first. So that if I go back to that first top of the triangle, the unacceptable risk category contains a number of systems, for examples, that are completely prohibited. So the idea is that their risk cannot really be mitigated. Now, this is where a lot of the interest was in the early days of this proposal. I think it has actually moved on and widened out. It's a very odd list. It seems to me to be quite arbitrary. It doesn't really get explicated by an overarching set of principles. It doesn't get explicated by, say, what most obviously breaches, say, the EU Charter of Rights. most of the action, and I think Petra will probably refer to this, has been around real-time law enforcement biometric identification. Okay, most commonly thought of as face recognition or smart surveillance. Okay, so the idea is, and this is a huge fight that is ongoing, the idea is that they would be banned, right? That sounds good, I think, to a human rights oriented audience. There's a huge amount of evidence about their discriminatory potential, their repressive potential, their anti-free speech potential, etc., etc. But it's a very limited ban, okay? It's only law enforcement. It's only publicly accessible spaces, which does not include online spaces, interestingly. It's only real time. So if, as happens a lot now, video surveillance might be collected in a public square or whatever, and then used later for smart processing, say emotion recognition, say lip reading, say all kinds of later work, then that will not be covered by this ban because it's only real-time, remote, publicly accessible and law enforcement. And then on top of that, it has a large number of exceptions which might well swallow the rule in most cases, because is there not a time when the use of face recognition in a public place is not necessary for, say, preventing, imminent terrorist attacks? That's probably a problem that could be raised in almost all major conurbations these days. So the prohibited section is, I think, probably fair to say disappointing, at least to civil society. And I think there is still going to be fights going on there. But a lot of the energy has moved to what you might call the kind of meat and two potatoes of the act, which is high risk. Now, high risk, again, notice, is not set out by any kind of qualitative criteria, right? It's not set out by any kind of risk scoring that you could imagine as to which human rights might be impacted or which interests might be impacted or which social communal values might be impacted. Obviously, these were thought about, but what has ended up is a list, okay? And this is the list. Now, on the list, as Petra is going to come on to talk about, is migration, asylum, and border control management. There are a number of other categories, as you can see, including law enforcement, some law enforcement functions, administration of justice, including things like robo-justice. So if we believed in automated sentencing, that would come within that. Most of these, as you can see, are actually more on the public sector side. As I say, none of these are the big ticket AI items. They're not social media, they're not search, they're not translation, they're not ad targeting. None of these are in high risk because they're dealt with by other acts. Okay. And in the private sector, the two that are really kind of crucial here, I think, are education and employment. And also perhaps essential private services, whatever that means, right? So there's going to be a big bit of interpretative work there too. But to a large extent, as I say, these high-risk systems are not universal and they are a bit niche. So one of the complaints, again, I'm sort of cutting in my critique as I go, is this point, that this is an arbitrary list, that it is only risk-based in a rather illusory sense, in that there is no enumeration of risks and there is no scoring system for risks. And on top of that, there is only a quite limited ability for these lists to be changed, right? These are categories, and under these categories, particular systems are mentioned. Now, there is provision for the Commission to add to the list of systems under the categories, but there is not provision right now to add new categories entirely. So that's quite inflexible. And most people think that the time the Commission would take to, be asked to and get its act together to add new systems, new services, would be so long that the world would have moved on anyway. So it may well be that this is really where the AIA is frozen in aspect. And that does not seem to me to be a good approach to as dynamic and fast moving a field as AI. I mean, if you look at the headlines, every day there's a new scare story, and some of them will be ones we have not thought of or what. And indeed, there is a good example of that, which I'm not really going to talk about here, which is that when the AI Act was being, modeled, built, all the expert groups were being had, we did not have what are now called large language models, things like GPT-3, that can do a very wide range of functions such as translations, generating speech, creating voice assistants, making chatbots look like humans, etc., etc. They were not therefore really part of the Act. And again, now there is quite a struggle going on between various groups as to how, if at all, they should be included in the Act. So it's already proving to not be future-proof. Right. And this is when we're only a year into the arguing. It hasn't even passed yet. So, okay, what happens if your AI system is high risk? Right. This is really the crucial part of the Act. Well, in that case, there are a number of requirements in Articles 8 to 15 that are sometimes called the essential requirements. I sometimes call them technical mandates. And these are really the ex ante part. These are the things that have to be done before the system can be signed off as compliant with the Act, right? Now, remember, this only applies to the high risk AI, but it's a good list. Right. This is a list, again, where I think we have one of the positive aspects of the Act. Right. So primarily, these are the two I've highlighted, though all of these are important. Transparency is important. Accuracy is obviously important. But I think these are the two real knock 'em out ones. OK, so the first is data and data governance, which used to be called data quality. And this is the idea that if you're building AI, it's very machine learning oriented. It's not very oriented towards that wider scope. Then you do it using data. You do it by training a system using training data. You then test if the system works using testing data, and you validate your system using validation. And the problem, as we've seen in endless, scare stories, journalist stories that have come up through the critical advocacy, civil society, is that often these testing sets are not representative. So, for example, most classically, I think we've had work showing that face recognition systems, smart face recognition systems, recognize Black people, people of color, particularly, I think, women of color, particularly badly, because they were less included in the training sets, which, and this is another whole story, are often taken from scraping the internet or from commercial training sets that are provided by people like Clearview. And they are often scraped from an internet that is predominantly full of white Western, perhaps, celebrities, etc., students. And so there was an underrepresentation of minorities, and therefore the systems do less well on minorities. And this has real implications, because if you take another current example, Uber in London, to comply with licensing requirements, do face recognition on their drivers, right? To check that the driver is the person they say they are, because they're required to do that to meet the licensing requirements of Transport for London. This is a London issue, okay? But it's probably replicated elsewhere. And that face recognition does badly on their drivers of color, which happen to be the majority of their drivers, right? And this is one of the points that the Uber drivers are taking to court right now. I think they're in court today about it, in fact, in Amsterdam. So this is not an arbitrary, abstract thing. So I think that this Article 10 on data quality is very important. People have said that this is unreasonable. I think the wording is going to be tweaked to say that these data sets should be free of errors, for example, is a bit of a too much. It should be something like to the best of their ability, having done due diligence, something like that. But in principle, it's a good article. And the other one I would point towards, I think, which is, going to be very difficult again, is human oversight. Now, some people get this mixed up, human oversight in Article 14, with some of the ideas in the GDPR. It's really quite different, and it's really quite extensive. So the idea here is that when these systems are made, right, they might be delivered as AI as a service, they might be sold on. If you take one example I often use, like an automated hiring system that people like HireView produce, they might code that up in America, but then they might sell it or license it to, let's say, a university in the UK, right? And that university might work with HireView, providing previous examples of who they had hired and so forth, okay? So the point is, when the service is sold on to a downstream user or deployer, can they actually control the system? Do they know enough to have oversight over it? Can they combat automation bias? So computer says no, computer says don't take this applicant, right? Can they actually pull the switch and say no? So this system is supposed to be built by the top level provider in a way that allows it to be controlled and overseen by the downstream users, okay, by which I mean the deployers. Now, that's going to be a very difficult ask, and I think that's going to cause issues as well. So I have more there. If anyone wants it, I'm quite happy to supply these slides. So let me just, I can see Nora looking worried because she's turned her camera on. Let me just go over a few of the critiques I've just made and maybe add a few more in, and then I'll stop, okay? So here's my ongoing list. First of all, one I've mentioned, why do we have no reviewable, challengeable? Why can't we take a judicial review? How would you do it? There's no criteria. So why don't we have these contextual criteria for what are prohibited and what are high-risk systems? Because at the moment, it's not future-proofable and it's heavily politicized, particularly in relation to the prohibited systems, okay? Now, the point I made at the start about this being modeled on the idea of product safety and tangible products, and that placed most, if not all, the obligations on the top-level manufacturer. When you pass that down to the AI system, as I've just explained, it's a really different ballpark, right? You've got an AI life cycle in which, say, training sets are assembled, which are bought in by someone big, let's say like Google or Microsoft or someone like that. They might create quite a general AI system that then gets integrated maybe as a call, as an API into downstream systems, which might provide other functionality. And they may learn as they go into operation. They may acquire more training data. And this kind of cyclical nature of AI, in which it changes, grows, and possibly acquires new harmful impacts, is not recognized well at all in the AI Act. Most of the action on this ex ante idea, which, as I say, has advantages in some ways, but most of the action is right at the start with the provider of the service, who basically replaces the idea of manufacturer. And there is a need to look at this and try and make it provide safety and guarantees of human rights and fundamental values throughout the life cycle of the AI system. Okay, I'll skip the next one. Oh God, what happened there? Sorry, that's very strange. Okay, I'll just talk because something very strange happened there. I was going to say the other main problems, I think, are enforcement, right? Because there's very little effective enforcement built into this system. The original certification as meeting high risk standards is going to be mainly done by self-certification. I think we can all think of the difficulties of self-certification within the context of profit-driven business models. And at the other end, where if you take the data protection regulation as an example, obviously we have problems with data protection authorities in that they're under-resourced and they're sometimes politicized. But they are doing a relatively good ongoing job of being a regulator, whereas that kind of post-factum enforcement mechanism is much more light touch with the Artificial Intelligence Act. And it is quite likely also that enforcement, that post-factum enforcement, will fall on the same people that the data protection authorities, who are already overworked, underfunded, and don't have enough technical information. And the final point I'd make, which I think, again, Petra might want to pick up, is the AI Act says almost nothing about data subjects, what we call data subjects within DP world, okay? The people who are not always data subjects, because it's not always personal data, but the people who are affected by these systems, right, which is the terminology we're now using at ADA, right, sometimes also called the decision subjects. Because, as I've said a couple of times now, the focus is very much on the top level provider getting it right, and possibly a few obligations on the deployer of the system in context. But there is no locus, almost no mention at all, of the people affected, right? And they don't have a role in that certification at the start. They don't have a role to make complaints at the end. And they don't have a role in the technical standard setting organizations that are going to translate the rules in the middle. right? So none of this is very satisfactory. And the one thing that is happening is that some of the reports that are coming out from the European Parliament look like they are going to try or are trying to address that. And I'll stop there. Sorry.
Thank you.
Stop share. There we go.
Thank you so much, Lillian. I have to say it is hugely impressive that you were able to provide such an in-depth overview of what is an incredibly comprehensive piece of legislation and provide, a very important critique of it with, some very, I think, significant provocations. I have so many points I would love to respond to, but just very quickly, I think the points that you raised regarding countering automation bias is a very important one. And I think that's hugely relevant, I really like the way you framed how there's currently a bonanza of EU policymaking at the moment in all matters digital and AI. And I think a lot of the issues that you raised, the trends and the critiques, I think they apply to that entire package regarding the Digital Markets Act and Services Act and so on. I think those critiques are quite relevant across the board, across that whole package. And I think the responsibility of deployers, and you go into this, of course, in more detail in your report, and, the renaming of them, providing a lot more clarification about what the role of users actually means when in de facto practice, it's deployers. I think that's hugely important for legal certainty, which I think for compliance implementation is really what data protection authorities, any regulators, and anyone coming from a fundamental rights perspective is going to be hugely invested in. So I think that's a very significant point. And then, of course, I think contextual criteria for what constitutes a high-risk AI system is just such an important point. And it's quite striking that in the annexes, there are literal examples, but there is none of that contextual criteria, which is quite surprising. It's a notable lacuna and a very important one I think you've highlighted. And just to stress to everybody that this proposal of the EU AI Act, it was published in April 2021, and it's at the beginning of its pre-legislative scrutiny stages. So we have some way to go before this is finalized. And I'm definitely of the persuasion that Professor Edwards' report will be hugely influential in its development. So let's watch this space, everyone. But before I get carried away, I really must give the floor to our other leading expert, Petra. I'm really looking forward to hearing her views and insights on this. Petra, whenever you're ready. Thank you.
Thank you so much, Nora, and thank you, Professor Edwards, for such a comprehensive overview of this really important piece of legislation. I think even for me, as someone who's been trying to understand how the AI Act is playing out in the migration space, it's really, really helpful to have these conversations from a much broader perspective. But I really want to pick up on the last point that you ended with, Professor Edwards, and that's the kind of silences that are in the Act itself. Because for me, as someone who's trying to understand how technology is experienced at some of the sharpest edges of our world, mostly in migration and border situations, one thing that struck me immediately about the AI Act is the fact that it really does not talk about the people who are affected, the people who are often at the sharpest edges of technological innovation. And, that I think, of course, goes beyond migration and border contexts, but that's the kind of milieu that I find myself in. And perhaps my remarks will be grounded in this particular context because I think it is a very useful one. It's a very opaque and discretionary space of decision-making already, one which is further obfuscated when we start automating, either partially or fully, the types of really high-risk, life-altering decisions that we're talking about when we look at the ambit of migration management and AI tech that is experienced there. And I think, again, what's fascinating about the AI Act is how it really shows us the importance of also looking at the way that legislation is put together from a power and privilege perspective. Because at the end of the day, technology is about power over particular groups, power that is vested in really important actors in the political economy that has sprung up around the development and deployment of technology, and also the power to make certain decisions and definitions be the ones that get inculcated into our laws and regulatory mechanisms. There's a reason why certain elements and aspects of border management technology is not included in the outright ban that Professor Edwards was talking about in the kind of pyramid structure of the risk assessment that the Act really has. Because at the end of the day, who really gets to decide what counts as risky behavior or a risky traveler? It's oftentimes the powerful entities that we interact with, the states, and also the private actors that are involved in the development and deployment of technology that disproportionately impacts people who are marginalized and made re-marginalized historically as well. But I think just for the purposes of my brief interventions, I think it's important to talk about the migration management ecosystem as a whole, because really what we have been seeing over the last few years is this proliferation of technology at every single point of a person's migration journey. We're really talking about a wide gamut of technologies, from unpiloted drone surveillance that's used in the Mediterranean and Aegean seas. We're talking about proposed AI lie detector machines that got a lot of media attention over the last few years. We're talking about automated decision-making making its way into immigration and refugee processing. But a lot of this tech is experimental. And while the AI Act does address border technologies writ large as a high-risk category, of course, as Professor Edwards already mentioned, there are huge carve-outs that are very, very concerning. Before I conclude with some recommendations that myself and colleagues have been formulating over the last 6 months as a result of the AI Act being tabled last year, I do want to share a few photos. I hope that's okay. My connection is a bit unstable because I'm actually calling you from the island of Lesbos, which is in Greece, and it is an area where technology is often being tested out on people on the move. But I just find sometimes when we talk about technology, particularly the way that it's playing out in migration, it can seem very abstract. But what does it actually feel like to see this tech in practice? What does it feel like for a person seeking safety to be put in a camp like the one you're looking at right here on the island of Kos, for example, one of the 5 camps that are currently being constructed here in Greece and funded by EU money that include all sorts of AI type technology, biometric collection at the door, drone surveillance, algorithmic motion detection software, and many more things that oftentimes are not even made public. Again, these are the ways that the camps look and feel. There's the kind of traditional surveillance, the traditional securitization mechanisms, but also this more advanced technology, like I was mentioning, the biometrics, the datafication of the refugee response. And, for me, as an anthropologist and a lawyer, I try and toggle between these two hats as much as possible. Because at the end of the day, as we've been talking about all throughout this event, this is all really about people and the data subjects at the center of all of this. And what really is important is to highlight, how do people actually feel when they are impacted by this technology? I've been tracking this now since about 2018, so it's been a few years. And one conversation in particular sticks out for me. I had a conversation with a young mother from Afghanistan on the eve of her basically forcible transfer into one of these high securitized, high-tech camps. And she was really scared. She spoke about the fear and the kind of dislocation and this omnipresent surveillance that everyone was really worried about. And she quickly typed this message to me, and it says, if we go there, we will go crazy. And really what I want to leave with is this. The context matters when we start regulating and talking about governance around something as amorphous and difficult to define as AI, automated decision-making, and this technologies. When we're talking about opaque and discretionary context of migration, we need to drill down and think about what is actually happening on the ground. How are people experiencing these sharpest manifestations of tech? And why are there particular gaps and silences in as comprehensive of a piece of legislation as the AI Act? Because at the end of the day, it is about power. It's about questions around who gets to participate around proposed innovations and their governance. It's about why does very little oversight exist over these experimental technologies at and around the border. And it's also a little bit about the hubris of big tech, or this techno-solutionism that we see all around the world, where the allure of quick fixes doesn't really address the systemic reasons why people are forced to migrate in the first place. So what to do about this? A coalition of partners, including myself, folks at EDRI, Privacy International, Access Now, State Watch, and PICUM, the platform for undocumented persons in Europe, have put together a list of recommendations how to amend the AI Act. I will share them with you in the chat. But just briefly, for example, we're calling for an update on the list of prohibited practices to include a variety of other things that impinge on migration, such as individualized AI-based risk assessments, the ban on AI polygraphs at the border and generally, ban on predictive analytics that are used for the interdiction or curtailing or prevention of migration, so essentially pushback operations, and a full prohibition on biometric identification in public spaces that does include borders and migration contexts. There's also a recommendation for further oversight and also a recommendation to amend Article 83 to also ensure that all the big IT databases are also within the scope of the AI Act. So I will share this with you in the chat, and I hope that we will have the last remaining minutes for some good questions and answers. Thanks.
Thanks so much, Petra. That was a really fantastic intervention. I think it spoke very well to Lillian's more high-level points, and it puts it in context in terms of one of those very significant areas of high-risk AI systems in Annex 3. And I think the recommendations that you made, particularly regarding the need for contextual criteria, it speaks very well to Lillian's presentation in terms of the power asymmetries that you mentioned, and then the sub-recommendation or the related recommendation that you highlighted about individual risk assessments, which is a really interesting point in terms of how does that relate to the types of technologies that the public sector or the public sector in collaboration with the private sector are using in terms of how these systems are not just using data, but also the infrastructure of these systems. Is a very interesting policy conversation happening at the moment about the role of the private sector, not just in processing data, but in providing the infrastructure that's processing the data, but that they don't store it. And then where does that place then the extent of their responsibilities in terms of our understandings from the GDPR, in terms of joint controllers and processors? And I think, that's a really important point when you talk about border control, because, your focus was on these, fantastic examples of, the physical devices that are used that will make these recommendations, these very crucial moments about people's freedom of movement. And in some cases, people's very livelihoods will depend on these recommendations. And I think that goes back to a very significant point that Lillian's presentation raised about automation bias. How is not just automation bias being countered in terms of any safeguards under the EU AI Act, but those power asymmetries? How is that imbalance of that relationship between the deployers and, as you mentioned, the affected data subjects? And I think, Lillian also mentioned this very significant point in her presentation about the lack of very robust fundamental rights standards that are in the EU AI Act. There is some reference, and I agree with Lillian that it's definitely a positive element to see so many ex-ante safeguards in place. I don't know if I'm as optimistic as Lillian in terms of some of the impact assessment proposals that have been put forward, because I feel as if we seem to go from EU legislation to EU legislation. We had the data protection impact assessments, which I think are still under review and evaluation, but already we're in policy conversations about new impact assessments, about fundamental rights impact assessments, when I feel as if we haven't really had the opportunity yet to do any due diligence about how these ex-ante safeguards are actually working in practice. And I think that should be part of a much broader conversation in the drafting and the review of the EU AI Act. I mean, when we talk about impact assessments, are we talking about the kinds of impact assessments that you've just mentioned, Petra, in terms of individualized, a case-by-case analysis? Or, are we talking about broader impact assessments with regards to groups and specific fundamental rights? This should be a more diverse and global conversation in terms of how high-risk AI systems are going to be regulated. And I agree with you that I do think, and both you and Petra, that I do think that there is certainly some potential and promise in this framework being put forward by the EU institutions as initially drafted by the European Commission, but it's by no means perfect. And I think, the really excellent, insightful critiques that you've provided in both these recent reports, I think they provide some really insightful legal critiques and some very rich food for thought for a lot of policymakers, not just within Europe, but also elsewhere. If it's not a gold standard to be adopted wholesale once this process is completed in a few years' time, then perhaps there are certain elements or safeguards that would be very relevant in other jurisdictions. But, as you rightly highlighted, there could be certain elements and constitutional divergences that just don't speak well to other jurisdictions in Africa, Asia, and so on. So whether this is the global gold standard, as you mentioned at the beginning, Lillian, as it's been positioned, I think that's yet to be confirmed as yet. But what we certainly have had today is an incredibly rich, insightful conversation and debate on how this can all be taken forward and what it means for individuals who will be affected by these systems and the attempts that lawmakers are making at the moment to ensure that innovation isn't stifled, that we get the best out of these AI systems for all kinds of legitimate purposes, for health, for education and employment, but that this doesn't come at the expense of the rights of the very vulnerable in society and everyone's rights in terms of fundamental rights perspectives. So I want to thank you both so much again for sharing your time and your expertise with us. And I hope everybody enjoyed the seminar today. And I hope that I'll be able to see you all at another event in the future. Thanks so much. Bye for now.